Hi, I'm Leah Halpert with Halpert Trademark Law. The first question I always get when I am doing a initial meeting, a free consultation with a new client or a potential client is, what exactly is the process? What are we going to do here? What is it going to look like? Please lay it out for me. So many people believe that for a trademark to get the protection, you just file an application at the trademark office, get a registration, and then that's that. And you're all protected. Well, it actually turns out to be that there is a lot more involved than just that one aspect. There's actually a three-phase process, and I like to break it up into these three kind of pillars. The first is inspection. So before filing anything, before trying to get any sort of registration for your trademark, you need to go through this inspection phase. And what this consists of is something called a comprehensive clearance search. This looks at whether or not, essentially, whether or not you and your trademarks are stepping on somebody else's rights. It looks at all of the trademarks in similar fields that come before you. So it's going to look at what is out there now and being used now before you start to use yours to make sure you're in the best position before starting. This clearance search does not look at just identical marks. That is one aspect. But per the legal standards, it is more of a likelihood of confusion. So anything that could be considered confusingly similar, as defined by trademark law, might be problematic. When you work with an experienced trademark attorney who has years and years of experience of understanding what is considered to be confusing per the trademark law, you will end up getting this report at the end of this clearance search. The report goes through an entire analysis. It's essentially a risk analysis. You are going to get an idea of what is out there. You are going to get an idea of what could be problematic. Nothing is guaranteed. You don't know if somebody's going to send a cease and desist letter or not, but you're going to have a really good roadmap. You're going to see up front before spending money, before really pushing a new product name or a new business name or a new logo, before spending all that money on marketing, you're going to have a real good idea up front whether or not the risks that are associated with doing so are something the business can handle. This inspection, it is imperative. It is imperative because the last thing anybody wants to do is receive a cease and desist letter after spending all of your hard-earned money marketing and building up a brand and having to rebrand. It is devastating to have to do that. And this inspection phase, this comprehensive clearance search, can 9 times out of 10 prevent something like that. Once the clearance search is done and you've analyzed all the risks with your attorney, you then go into the registration phase. And the registration phase is essentially getting the trademark registration at the US Trademark Office. This is going to give you nationwide exclusivity to use your brand's logos and slogans. And it also gets the trademark office on your team, essentially. They are going to start looking out for any trademarks that come after yours. So the opposite of inspection, it's anything now that's coming after yours that could cause confusion. They're going to keep an eye out at the trademark office itself for things like that and try to prevent it. But essentially, it's not really the trademark office's job to protect your trademark for you. It is the business owners. And that's why we have this third phase, protection. This is the ongoing monitoring to make sure throughout the life of your trademark, to make sure that no one else is infringing on your rights. Allowing somebody to infringe on your rights and allowing somebody else to use something similar to your trademark can dilute your rights, can make your rights smaller, can grant you even less than what you should have. So this ongoing protection phase consists of weekly monitoring. At Halpert Trademark Law, we do weekly monitoring of your trademarks to make sure nothing is in use and nothing has been filed at the trademark office, that's going to be confusingly similar. That's going to cause a risk or potential damage to your reputation. Um, these are essentially the three phases, and it goes from the development of your trademark all the way till you've decided you're no longer using this and it's the end of the life of the trademark. If you have any questions or want to discuss any of these phases anymore, please contact me at leah@helpertmlaw.com or go to my website and register for a 15-minute free consultation. I would love to help you and talk more about your trademark journey with you.